Good morning, ladies and gentlemen. This is my 10th video, 10th, in the matter of David versus AT&T et al. This is a case going on during the last 36 long years with no discovery, no hearing, no trial, going from one kangaroo court to the other. Those who have watched my previous documentaries in YouTube under David versus AT&T part 7, 8 and 9 will tell the whole story. To save the time, the issue before the U.S. Supreme Court, as decided by it on October 2, 2017 was, I'm going to read from the Supreme Court's docket sheet, which will be interesting for many of you to read, to understand. The Supreme Court, this is the site. The Supreme Court on October 2, 2017 states in its order, you have to hear first, the motion for leave to proceed in forma pauperis is denied and the petition for a writ of mandamus dismissed. See Rule 39.8, period. As the petitioner has repeatedly abused this court's process, the clerk is directed not to accept any further petitions in non-criminal matters from petitioner unless the docketing fee required by Rule 38 is paid and the petition is submitted in compliance with Rule 33.1, period. See Martin versus District of Columbia Court of Appeals, 406, U.S. 1, 1992, per query. That's the order. Now, you can read a court's order partially and act on it. You have to read the whole sentence, which is relevant here is, unless the docketing fee required by Rule 38A is paid and the petition is submitted in compliance with Rule 33.1. On December 28, 2017, I submitted a brief, 40 sets of my brief pursuant to the rules. I paid a bank draft drawn on Chase Manhattan Bank in New York for $300. As soon as this crazy woman, whose title is shown as legal analyst or case analyst, she returned the whole thing back to me, to India. What I'm doing is complying with the court's order. She is mentioning on the top of her letter case number 15-9100, which was dismissed long time ago. And in the body of the letter, she is referring to case number 16-9624. So we are going to go back to what the court did before. The new case was submitted in 2016 based on case number 224. So in the body of the letter, she is referring to the same letter, the same case number 169-624 on the top, she's talking something else. I complied with the court's rules. I sent a written complaint to Chief Justice John G. Roberts to look into this. I sent him the check back to him, and he apparently sent it back to the clerk's office. The clerk office, by another deputy clerk by the name Jeffrey Atkins, in his letter dated February 16, which you see here, advised me the petition is dismissed, which means it's part of the order. He doesn't want to read line 4 and 5. Then I wrote to the clerk of the court, Chief Clerk Scott Harris, drawing his attention to the inconsistencies what these two people are telling. I sent him a registered letter on March 23, citing the reasons. Okay? No answer. Then I sent another letter. What happened was Mr. Jeffrey Atkinson wrote me another letter dated April 10, 2018. Telling me under Article 3 of the Constitution of the United States, the court has no jurisdiction. Folks, it is not for the clerk of the court or a deputy clerk of the court to tell me that. It is for the justices assigned to the U.S. Supreme Court to tell me. You have to hear the funny things here. You have to understand the background. The judge, the first judge, the district judge, was going with the attorney for the defendant, meeting her in his home, her home, and another place in Atlanta, which he confessed in a taped telephone conversation consented by him. I notified the FBI and Chief Justice then Warren Burger. The judge resigned from the bench within maybe few days after my complaint. He first recused and resigned. The ball was passed on to another judge of the defendant's choice in another town, in Tampa. Chief Judge William Terrell Hodges asserted his divine theory. The king can do no wrong. He says he has the jurisdiction, although I have nothing to do with the Tampa. The course of action didn't arise in Tampa. None of the parties were in Tampa. How can a court that has no jurisdiction consider my case? When I made a motion in Standard for him to transfer the case to New York, where I was then living, and where the corporate defendant AT&T had their corporate headquarters there then, he says no. Does he have any vested interest in the outcome of the case? Yes. So from 1982 I filed the case until he dismissed the case based on a case law planted by the defendants themselves. That case law is called McDonald versus AT&T and Michigan Bell, Orville E. McDonald. Thus was decided by the state court, which was overthrown by the Supreme Court in Aubrey versus Energy. The clerk of the court, his name is Donald Brown, he altered the court's order. You have to understand the name of the game going on here. It's a big corporation with enormous political and economic powers to beat this little guy. In America, if you are involved in a car accident They will chase the ambulance, find out, get his case, because they get 1/3. But when we have a case against a major corporation, all these so-called Martindale Hubbard licensed lawyers, we wrote to about 200 or more of them, not even a response, because they were all afraid of this mafia corporation and their tactics. Now, you have to understand what happened. The clerk altered the court's order, Donald Brown. He was fired by the court subsequently after 2 judges in that court reported him, I think Patricia Fawcett and Kendall Sharp, reported this guy, Donald Brown, as incompetent. He was fired. You have seen in the prior documentaries. We will show you the documentary, or what is in the Sentinel Stars report. Now, the Defendants Council all of them are licensed to practice before the U.S. Supreme Court, filed a false jurisdictional statement in their brief in opposition, telling the U.S. Court of Appeals that it has jurisdiction because the order so issued by the clerk is final and appealable. The original order of the court, Judge Hodges, yes, was to dismiss the case without prejudice if I didn't return the consideration to the employee, pursuant to the Michigan Court's decision. Okay? The judge denied the motion. He directed the parties to appear for a bifurcated trial to be decided. So from 1982 until 2018, 36 years, no bifurcated trial, no trial. The laws passed by the Congress remained as a paper tiger. The laws such as Title VII of the Civil Rights Act, Age Discrimination and Employment Act, what is called ADEA, ERISA, Employees Retirement Income Security Act, right to a jury trial, right to due process. None of them have been applied by these kangaroo courts. So, what happens? The case goes to another panel of the defendant's choice, to the 11th Circuit. The clerk of the court at the 11th Circuit, his name was Miguel Cortes, I believe, he accepted the case. Although the Court of Appeal had no jurisdiction whatsoever to accept an interlocutory order under 28 U.S.C. 1291, because the Court of Appeal can only accept a judgment from a final decision, which has not happened. And that panel affirmed one word. The panel members, you have to understand, one of the panel members was bombed and murdered, Robert Vance. Second panel member, Clarence AllGood, took a gun and shot and killed himself. Okay? These are all secrets which the United States government and the U.S. courts do not want us to know why this is happening. One of the appellate courts in the country, United States Court of Appeals for the 11th Circuit, why this case goes only to one person, same clerk, same routing clerk, J.L. Edmondson. I made a motion pursuant to Federal Rules of Appeal Procedure 35, seeking an en banc hearing. It never goes to the en banc court. It only goes to this particular judge, who is a pro-corporation puppet. J.L. had mentioned, there are more than 27 judges in that court, both senior and active. It never goes to the members in the active panel or other members. Why? How the scheme is taking place. So, now the case goes to the U.S. Supreme Court, and before the Supreme Court, the same lawyer, Peter Seelover, who then represented the defendants and who was a partner, I believe, at the Carlton Field Emanuel Cutler and Smith law firm in Tampa, who filed a jurisdictional statement at the court below, at the 11th Circuit. When the case goes to the U.S. Supreme Court, he says, Your Honors, this case has no jurisdiction. This court has no jurisdiction because the court below issued a temporary order which may be subject to change at any time. For your information, the case number is 86-6168. I have the complete set of the brief filed by the defendant. So here in the court below, it is a final judgment on the merit, persuaded the 11th Circuit Court of Appeal to accept the case. Before the Supreme Court is an interlocutory order. See that the contradicting statements, tactics of the corporate mafia. So the Supreme Court denies certiorari in 1986. 5 years later on, when I was working in another law firm and happened to read the law journal, and it clearly stated the difference between a dismissal without prejudice and a dismissal on the merit. So, I filed a motion under Rule 60 of the Federal Rules of Civil Procedure before Judge Hodges. Took time for him to render a decision on January 30th, 1991, that is 5 years after the Supreme Court denied certiorari, admitting the clerk of the court, Donald Brown, had made a mistake. It's not a simple mistake, it's a fatal error. So the court had no jurisdiction to start with, the 11th Circuit. Now he is telling, yeah, we made a mistake. I moved to the 11th Circuit Court of Appeals, and the same judge, J.L. Edmondson, only gets the case. The other judges are competent. They know what's going on here. So it doesn't go to them. Folks, now in this case here, before the Supreme Court of the United States, there are two problems. One problem is the Supreme Court has held in numerous cases, not one, several cases, that when the court lacks jurisdiction, its judgment is a nullity. I cited at least half a dozen cases from the U.S. Supreme Court itself. Now, if the court below had no jurisdiction, how can that court accept the case and affirm? That's the legal question I have raised. Now you've got to understand the name of the game in the Supreme Court clerk's office. As I told you, the clerk of the court has no legal authority to rule on a motion. I submitted a motion under Rule 22 of the Supreme Court rules, asking Justice Neil Gorsuch, who testified before the Senate Judiciary Committee, how he will decide a case. And his answer was, I will first read the facts of the case before coming to a legal conclusion. So that's why I especially referred this case to his attention, or to the justice assigned to the 11th Circuit, Clarence Thomas. The clerk's office will not give my motion made under Rule 22 to the justices. Why? I wrote another letter to Mr. Scott Harris on July 12th. Citing the reason, asking, first of all, the Supreme Court had stated at each term the Supreme Court hires fresh graduates from well-known universities to be clerks. Now this woman, Melissa Blalock, she is not a woman assigned to the justices. She's a clerk in the clerk's office. She can't decide questions of law, nor the other clerk, Jeffrey Hudkins. So Mr. Hudkins says in his April 10th letter, (2018), under Article 3 of the Constitution, the court has no jurisdiction. If the United States Supreme Court has no jurisdiction under Article 3 of the Constitution, as alleged by Jeffrey Hudkins in his letter dated April 10, 2018, how the court accepted the case in case number 169624. And the case was going on from 1982 until this day. This clerk has no authority to rule on a motion. Okay? But he does it. The peon cannot tell the boss what he should be doing. I am the litigant. The parties have not raised a question as to the jurisdiction of a court, and the party who violated the jurisdiction of the court to begin with is the clerk of the court at the Tampa by issuing an order contrary to what the judge said. And it is the defendant's counsel, Peter Sinaba, who, along with the ANSI Conway, filed false papers saying the 11th Circuit has jurisdiction. Okay? Now the broader legal question that I am raising is, if the clerks of the court have no authority to rule on a motion, how can they do that? And why the Chief Clerk, Scott Harris, is keeping quiet? He should have investigated the whole damn thing. When I showed them, I even drew their attention to my documentary in YouTube 7, part 7, 8 and 9. The name of the game going on there. Now, there is another procedure open to me to let the Solicitor General know to make a confession of error. Okay? Or to report the clerk of the court to do what he is required to do by getting an order. But who will issue the order? I can't force the clerk of the court to do his ministerial job. Folks, if you read the October 2, 2017 order, the Supreme Court cites a case, Martin, in its order dated October 2, 2017. One should be able to locate the case, which is not available from the PACER system, which is not available from Thomson Reuters, which is not available from the DC Circuit, which is not available from the U.S. Supreme Court itself. How can they compare my case similar to Martin? I don't know the facts of the case. I'm curious to know when they compare apple with oranges, they are the same. I can't accept what they are saying. And this judge who issued the opinion for the court, they should let the public know what is the Martin's case. What he did subsequently, that's not a consequences. They are citing a particular case and it is not available from the system, the entire system. How can they tell that my case is similar to Martin? I am raising here legal questions. I am fighting against the mightiest corporation in America. And I can't respond. They claimed once my case is frivolous and malicious, making allegations against this woman who is now a terrorist court judge. She is the one who screwed me up by going to the judge's home and meeting him in private in his home, her home, and in Atlanta for influence peddling with the judge not to conduct a trial. Which ultimately brought his downfall in disgrace. So the players here are all doing everything in cahoots with each other. The clerk of the court, the Tampa Court, the clerk of the appellate court, and the clerk of the U.S. Supreme Court. What remedy, folks, I have? What remedy do I have with regard to the enforcement of the laws passed by the Congress? Namely, Title VII, ADA, RISA, jury trial, discoveries, nothing. I want the civilized world just to understand the gimmicks going on. 36 long years, these kangaroo courts passing the ball from one player to the other, kicking the ball among themselves. It doesn't go to honorable judges in any of the courts. Okay? The Supreme Court has a limitation. 80 cases they will consider out of 10,000. So 9,920 cases filed, howsoever meritorious they may be, they are automatically rejected. They have no recourse. Everybody has to take the law into their own hands like the other guy did. Moody, who bombed Judge Vance. I tried to conduct him in the prison where he was executed, before he was executed. They won't connect me. I wrote him a letter. No response. So all what is going on in the courts, generally in the American courts, they are all bull. Folks, I'm sure you listen to this, my videos, you will know what's going on here. I'm a 79-year-old person, but I'm fighting like a warrior to fight against the mightiest corporation in America, to expose them, like Richard Fine did it. What was happening in the courts in California, for which he's a PhD guy. You can watch his documentary in YouTube, his story. He exposed the corrupt courts where judges were taking money under the table. So, as a reprisal, they put him in jail with no charges. But eventually, they let him go. So he sought after, and those who sentenced him, they had to resign. This is the American system of justice. The rule of the jungle, they call it the rule of law. Thank you, ladies and gentlemen.